67. Should I allow an employee to resign by mutual consent?
If you've ever felt inclined to allow an individual to resign voluntarily rather than be discharged for cause, don't be too hard on yourself. You demonstrated humanity and compassion. Remember, though, that ambiguity in the termination process can be held against you. Generally speaking, if you've got just cause to discharge the employee, termination is appropriate. Lessening the blow by offering the employee 2 weeks' pay in lieu of notice or continued medical benefits, or by placing the individual on inactive status while keeping her on the payroll, can be interpreted as signs of weakness on your part. Worse, it can be interpreted as an acknowledgement that the company was partly at fault and may be trying to cover up something. Tell me more. Avoid sugarcoating terminations as much as possible. Assuming you've accorded the employee workplace due process in the form of progressive discipline, then follow your company's policies and past practices, and avoid exceptions. Terminations for cause aren't fun, but they should be a straightforward management practice. A former employee looking to avert blame may distort your good intentions. Exceptions all too often provide fodder for plaintiff attorneys, who may attempt to attach ill motives to your benevolent actions. On the other hand, there's something to be said for allowing employees to resign of their own accord. Note that unilateral resignations, as opposed to mutual resignations, do not allow for severance pay, continued medical benefits, or any other company-sponsored perks. They simply allow the employer to resign, rather than be terminated for cause. As such, it would be much harder for a plaintiff attorney to somehow distort your actions as a sign of weakness. In addition, anytime you can avoid being the moving party in a termination, you should, because you'll naturally avoid certain causes of action that a plaintiff attorney could otherwise levy at you. The question remains, when should this option be mentioned? It wouldn't be appropriate, for example, to hold a termination meeting with final check and COBRA paperwork in hand and then simply allow the employee to resign. By that time, you'll have established a written record of termination for cause. Allowing a resignation during the termination meeting would consequently create an inconsistent paper trail. On the other hand, if an employee appears to have violated the terms of a final written warning and you're speaking with the employee to learn his side of the story, you might suggest the following. Dennis, I understand that you were in a rush to meet a deadline and that you assumed that your coworker would pull the satellite feed. Still, satellite feeds are ultimately your responsibility. You were given a final written warning 2 weeks ago documenting that your failure to pull a particular feed caused the station to miss airing a TV commercial. Today it appears that you've missed another feed during your shift with the same result. Now that I've heard your side of the story, I'll need to discuss this with station management. However, you need to know that this could result in your termination. I know you've had difficulty in your job since you joined us last year. Maybe it's just not a good fit. You know, right person, wrong job. If it's easier for you to resign if we find that you violated your final written warning, I'd certainly understand that. I simply want you to have that choice if you feel it would be better for your career. We'll respect whatever decision you make. What are your thoughts? Given that choice, the employee may take the path of least resistance and simply resign. That avoids the loss of face associated with a termination for cause. It also saves you from having to conduct a termination meeting. Is there a downside for the company or the employee? There's typically no downside for the company, unless the employee argues that he was constructively discharged, that is, that he had no choice in the matter. However, treating people with dignity and respect and allowing them to have some control over their future will typically beget appreciation, not anger. On the other hand, there could be a downside for the employee. If he unilaterally resigns, he will technically be considered the moving party, or the party that initiated the terminating event. As such, he could be denied unemployment insurance. Unemployment is typically granted by the state when the company is the moving party and the employee had no control over the separation. Your company may choose not to contest unemployment, that is, challenge the employee's claim for unemployment benefits. Remember, though, that the state determines eligibility. If the employee says he quit, the state may very well deny a benefits award. That information should be shared up front with an employee who is considering a resignation while a termination decision is pending. It's only fair that you share the long-term results of his decision that could impact him after he has left your company.